Welcome to Case Flash, brought to you by the CBA Family Law section. Today's Case Flash is on the final judgment rule and Conn v. Hillyer. But first, a brief moment on the final judgment rule. Generally, interlocutory decisions cannot be appealed, and the public policy behind that is to discourage piecemeal appeals and also to facilitate the speedy and orderly disposition of cases at the trial court level. However, there are many exceptions to this general rule. The leading case on the exceptions is State v. Curcio. There are two prongs in Curcio. Under Curcio, the first prong, when an order or action terminates a separate or distinct proceeding, it can be immediately appealed. And the second prong is when the order or action so concludes the rights of the parties that further proceedings cannot affect them. The Curcio test sounds straightforward, but there are huge gray areas. That brings us to Conn v. Hillyer. The basic facts are straightforward. The trial court awarded joint legal custody to the two never-married parents and primary residential custody to the plaintiff mother. The plaintiff began to withhold visitation based on serious allegations, which allegations were not substantiated in investigations by DCF and the police. The mother was held in contempt 3 different times. On the 4th time, the trial court ordered that the Family Relations Office immediately enroll the defendant and the child into supervised visitation and also ordered that the mother pay for it. The trial court also continued the motion for contempt to a future date, which also was the completion date for a family relations study, and reserved a further decision on the motion until that time. The plaintiff appealed, the appellate court reversed, the Supreme Court granted certification, then the Supreme Court reversed the appellate court. It reasoned that a civil contempt order that requires a contemptor to incur a cost or take specific coercive action is a final judgment and immediately appealable. The Supreme Court observed the unique place that family courts hold in this state's jurisprudence. So, Judge Gordon, does this case resolve once and for all what is a final judgment?
Well, I wish it were that straightforward. I don't think it resolves that question. I think it helps in terms of moving us along a continuum towards the answer to that question, because I think that in the decision itself and in the footnotes, we may have some hints about where this is going. But it certainly makes it clear that if you have contempt and a coercive action, you have a final judgment.
Attorney Palmer, what would have happened here if the mother were required to bring the child to supervised visitation, let's say 2 times a week, without a financial sanction? Would that have been a final judgment?
I think for purposes of contempt, that's where part of the gray area comes into play. If you read at page 2, I believe it's 215 or 217 of the opinion, near the end of the opinion, the Supreme Court specifically says that a civil contempt order requiring the contemptor to incur a cost or take a specific action is a final judgment for purposes of appeal. However, the example they give is clearly financial based. So the question is whether on the contempt side it would be a final order. I would say yes, based on the specific act language of the Supreme Court's opinion. However, there's a second basis which I think would cause this to be a final judgment, and that's under 46B56, because the court did not only enter financial orders subject to the contempt, but the court also entered additional custody and visitation orders by requiring supervision. So I think that forms a separate basis for the final judgment under the Curcio rule.
And do you think that there might have been some issues of mootness coming out of this if this instead had not had a financial component to the order, if this were a purely visitation, supervised visitation order?
In this specific case, based on the facts, I would say there's a real possibility that mootness could have been argued because custody, subsequent to the contempt hearing, custody was actually transferred to the father. So at that point, the contempt was essentially over because dad had his time with the child. So we have a totally separate set of family dynamics going on at this point.
Well, but the interesting thing about that, and that leads us to kind of where the footnote goes at the other end is, what's the case really about? Is it about the contempt, or is it about the sanction or coercive action? And I think it's interesting that one of the cases they talk about is Busey versus Busey. And in that case, there was no finding of contempt. There was an order that the individual pay for certain medical bills, but not a willful disobedience found. And they said that's not appealable on an interim basis because there was no finding of contempt. So I'm not sure what it is that is triggering it, because in the last footnote, they say that they're leaving for another day the issue of whether or not contempt alone will be sufficient for a final judgment and for appeal. And I think that's a really interesting question, because you could probably argue for and against that.
And there's some good reasons why contempt alone might be the reason for a final judgment. For example, it colors the proceedings going forward, and especially on something like an appeal, where there have been multiple contempt findings by the court, then that could be the basis to dismiss an appeal. So a contempt finding by itself matters.
Right, and then the other question to me was, you need to have contempt plus the coercive action, because you couldn't just have a coercive action, because there's a coercive nature to any number of things that a court orders. You could argue that every court order is coercive. I think I joked with you guys earlier that we don't issue requests, we issue orders. So maybe it is the contempt, and maybe in their discussions of the case, that was the discussion they really had, and maybe that gave rise to the footnote.
Would this have been a compromise decision then?
I don't think that it was so much a compromise decision, because I think they would have found under the previous cases that they've decided that this is what you have. You have contempt and coercion, and that gives rise to a final judgment. But when they were starting to talk about the issue of the coercion, and somebody might have said, well, what happens if you don't have that, or what happens if you only have that? And that would have raised the interesting things that we've been talking about.
Did either of you find it significant or remarkable, I would ask, that the court never addresses the parenting side of this, that they only focus on the monetary side?
I found that a little remarkable, because it seemed to me, from the perspective of the parents and of the child, what the importance of the order was the supervised visitation. I mean, the financial component, being ordered to pay some money, that matters. But what really was important here was being coerced to attend supervised visitation. But that is discussed. It's all over the facts. But they didn't go into analysis of that the way that they could have. They could have done more with Sweeney and Madigan and Taft, those cases that they cite, but they elected not to do that.
Though it is interesting that part of the reason for the supervised visitation, which we should make clear to people listening, is that it was for reunification. At least that was one of the stated purposes of the court. So we don't know whether or not it was because they were worried about the allegations, or whether it was basically designed for the reunification. So we don't know that the supervision was as important to them as what was the monetary sanction for her for having to pay. You also would have run into an interesting mootness question on that if you focused on the parenting, because we know that things in this family changed completely by the time the case got to the Supreme Court.
What happens if you have just the financial coercive order and not a contempt?
Well, I think you have Busey's there, and for instance, if you said, well, I find that she was sincere in her belief, but I find, or maybe this was the first time this had happened, and she was sincere in her beliefs, though mistaken, and the court said, no, the visitation has to take place, and we're going to monitor it for X, Y, or Z, and you're going to have to pay for it. I think you would have been squarely within Busey, and you probably would not have had a final judgment for purposes of appeal.
So you think it's probably the contempt plus?
I think it's the contempt plus.
Yeah. Okay. Attorney Palmer, why is the Conn case important?
I think it's important for two reasons. First reason is it attempts to clarify what a final judgment is for purposes of family cases. And there's some language in the case at page 213 where the Supreme Court says, this court has a long history of concluding that within the context of family matters, orders that wouldn't otherwise be considered interlocutory constitute appealable final judgments. Well, that sort of reminds me of the old pornography cases from the Supreme Court that says if you know it when you see it. And I think that's the approach that the Supreme Court has taken with regard to family cases. The second significant part of this decision is really significant for what the case doesn't do, which is a finding of contempt in and of itself a final judgment for purposes of appeal. And the Supreme Court directly leaves the matter open in footnote 7, where it writes, "We do not purport to decide whether a bare finding of contempt unaccompanied by sanctions is an appealable final judgment under cursio. We leave that issue for another day." It seems to me that this case was ripe for the court to make that determination, given the sort of temporary situation the parties were in 2009 when the finding of contempt was made. But clearly this opens the door for the next case to determine whether or not the finding of contempt unencumbered by sanctions would be a final judgment for purposes of appeal.
Okay. And I know that the case was not briefed in that way, where a contempt alone would be the final judgment. Family lawyers, I guess, will continue to struggle with what's the final judgment, but the Conn case does help better clarify the analysis that goes into it. Thank you very much for watching Case Flash.